Oh, hello. Today we're doing the second of 2 days of privileges. We're going to talk about waiver, which applies to any kind of privilege. We'll do psychotherapist-patient privilege, spousal privileges, and I had you read the additional reading packet, Proposed but Rejected Rule 504. As you know from the last class, this rule was not enacted, but it is a good common law statement of the actual privilege, although we'll talk about some important differences that have evolved since then in the common law. And the additional reading packet is white. It's a Perry Mason episode. It's really a shame we can't do a live session because it's a wonderful episode to watch, but I will be able to talk to you a little bit about the issues, and you should take a look at the additional reading packet on your own and kind of figure out what you think the answer should be. You know, when I'm back in town, we'll be able to talk about some of these issues, both in the review session that is scheduled, and I'm also planning on scheduling an additional review session during the last week so that you can come in with questions. Oh, and let me announce one piece of news. I've just submitted actual bar questions and multi-state bar questions going back to 1987. Boy, that's 20 years, isn't it? When I took the bar, and these will be a good practice for you. The particularly helpful questions are the multi-state questions, because otherwise there really isn't a good source that I know of for multiple choice questions. Okay, so here's what we'll do. First, as I mentioned, we'll talk about waiver, which applies to any kind of privilege. Then we'll talk about inadvertent disclosure, which is different than waiver, although sometimes courts kind of confuse the two. Inadvertent disclosure is where you really did want it to be a secret, but it leaked out somehow. We'll talk about the psychotherapist-patient privilege, and we'll pretty much follow the same structure with the psychotherapist-patient privilege that we followed with attorney-client. So we'll first say, you know, who is a patient, who is a therapist, what is privileged, and then we'll talk about the exceptions. And the exceptions are actually quite different than attorney-client, whereas the rest of this will look very familiar to you. We'll then talk about the spousal testimonial privilege and the spousal confidential privilege. Now, this may sound odd at first to you, like, well, they're two different kinds of privileges. And you already know about one type of testimonial privilege. That's the Fifth Amendment right? Because the Fifth Amendment right that the criminal defendant enjoys is a testimonial privilege. The defendant can refuse to get up on the stand altogether. And that should give you an idea then of what the spousal testimonial privilege is. That's the privilege for one spouse not to even testify against another spouse. Whereas the confidential privilege is like the privileges that we're talking about today and that we've talked about before. So the attorney-client privilege, the psychotherapist-patient privilege are confidential privileges, which is that you can't refuse to testify at all against your therapist, or a therapist against you, or against your attorney, or attorney against you. But there are certain aspects, confidential aspects of the relationship, of the communications between the two that are protected. And then last, we'll talk a little bit about California v. White, but I won't give you the whole kit and caboodle. All right, waiver. What is waiver? Well, here's the rule, and I'll tell you what to write. This is a proposed but not enacted 511. I didn't even have you read this. A person upon whom these rules confer a privilege against disclosure of the confidential matter or communication waives the privilege if he or his predecessor, while holder of the privilege, voluntarily discloses or consents to disclosure of any significant part of the matter or communication. Now, here's what you want to put in your notes. You want to write, you waive the privilege if you disclose or consent to the disclosure of a significant part of the matter. Now, what you should immediately realize is that you don't have to give up everything in order to give up everything. Now, why do they do this? Why don't they allow you to waive part? Well, the reason is they don't want you to strategically only waive the things that are in your favor. So basically, it's that if you consent to any bit being disclosed, you consent to everything being disclosed. The rule goes on to say, this rule does not apply if the disclosure is itself a privileged communication. And what you want to write in your notes is that no waiver occurs if the disclosure was covered by a different privilege. Well, this is easier to give an example of than to explain. For example, you tell your lawyer something that you told your therapist, right? Or, as you'll see in the White case, this would apply to a situation where, let me put my coffee down, where you tell your therapist something, right? And then your therapist tells it to his attorney. Now, there may be different privileges involved, but notice that the privilege is not lost as long as another privilege covers the subsequent communication. Let's talk about inadvertent disclosure. This is obviously different than privilege. Inadvertent disclosure is when something is disclosed but without your consent, so it's clearly not waived. Does inadvertent disclosure waive the privilege? The answer is technically no, but if we refer to a waiver loosely as give up some of the privilege, then most courts say sometimes. So sometimes inadvertent disclosure does, let's say, undermine the privilege. That would be a more accurate way to describe this. Well, when does it? Well, if it's negligent or reckless. So it's one of those situations where you're not voluntarily disclosing, so it's not a true waiver, but you're so sloppy that the courts will not reward you for your misbehavior. And the way to think about this is that once the cat is out of the bag, then it's not so clear that justice is being served by the information being suppressed. Because what happens is everybody knows it, but it can't be introduced into evidence, and it now starts to seem unjust. And so what the courts will say is, if you were negligent or reckless, you should have taken more precautions, we're going to allow the information to be introduced. And they might call it waiver, although it strictly is not waiver. Strictly it is that you've lost the confidentiality of the information. If it's massive, they're more likely to call inadvertent disclosure a waiver. If it's important, if it was relied on by the recipient of the disclosure, so the recipient used it to control their litigation strategy. Now you might say, well, gee, the more important it is, the more massive it is, the less likely you should allow to waive. But again, think about this, that the information is out, that it's going to look unjust, and of course the last reason is essentially that it's unfair to the recipient not to allow them to use the information if they relied on it. The main difference between sloppy inadvertent disclosure that does, quote-unquote, waive the privilege and true waiver is that partial disclosure doesn't mean that everything is waived. You don't have the same worries about strategic partial disclosure because you don't intend to disclose anything with inadvertent disclosure. And that will mean that partial disclosure that is inadvertent does not lead to waiver of all the information as it would if they were deliberate disclosure of part of the information. Okay, now at this point I'd say, are there any questions? And 10 years from now, there will be virtual students asking me questions, but not yet. So let's keep moving. Okay, psychotherapist-patient privilege. Now, I probably don't have to tell you how important it is to be able to go and talk to a counselor about your mental health problems or your emotional issues or your relationship issues and want it to be a secret. Even if there wasn't a psychotherapist-patient privilege, we would probably select out those therapists who promised us that they would never reveal the awful information that we are so willing to divulge. So we understand the rationale for the privilege. Now let's work the rule. So who is a patient? Rule 504 gives us some information. A patient is a person who consults or is examined or interviewed by a psychotherapist. And what you want to write is, a patient is anyone who consults with or is questioned by a psychotherapist. The language is quite good to put in your notes verbatim. A little difference for you California fans. If you're talking to a therapist for scientific purposes, for research, Federal Advisory Committee says it wouldn't protect you, and they're stating what they think is federal common law. California does protect statements made for research. Kind of a minor point. Note the similarity between the patient definition and client definition. Do you have to hire the therapist? And of course the answer is no. And what this does is protect consultation as well as actual patient, where you formalize the patient-therapist relationship. Okay, who is the therapist? Well, here you have some requirements. Under the common law, it was believed, let me get this all up on the slide before talking about it. Under common law, it was believed that you'd have to be a psychologist, a psychiatrist, or someone with a medical degree. And this was pretty elitist, actually. And what the Supreme Court in Jaffe very generously recognized is that a lot of people can't afford to go to a licensed psychiatrist. They are the most expensive, having MDs. Many cannot afford going to a licensed psychologist. A social worker who might have, say, a MSW is likely to be less expensive, and it's not fair to the poor that they can't receive the services they need. It probably wasn't a coincidence that the case that went up was a case where a police officer had shot some individual. The police officer was sued, and it was the police officer who had visited the social worker, which might have made the somewhat conservative Supreme Court a little more generous towards understanding the rights of the poor when they're poor policemen. But maybe only a cynic would say that. A patient must reasonably believe. Remember the rule for attorneys that you might go to a notario and still get protection? And the answer is yes. The rule is similar to attorney-client. So if you reasonably believe someone is a social worker and it turns out that they have no degree, no experience, and they just hang up a shingle saying psychiatric help offered here, that's good enough for the rule. Okay, what is privilege? What is privilege? Well, it looks just the same. Just the same. The general rule of privilege is that a patient has a privilege to refuse to disclose and to prevent any other person from disclosing confidential communications made for the purposes of diagnosis or treatment of his mental or emotional condition, including drug treatment. And what you want to write in your notes is confidential communications made for the purpose of mental diagnosis and treatment. Okay? So again, confidential communications, and I'm going to define that on the next slide, and made for the purpose of is similar to the attorney-client rule, where it's got to be made for the purpose of legal services, of obtaining or offering legal services. And here the point is diagnosis and treatment of some sort of mental condition. I should mention briefly that as far as the federal rules are concerned, and as far as the common law is concerned, as far as you're concerned, there is no physician-patient privilege. We'll find those things in California state law, but I don't have time to teach you that for purposes of my exam, and for the most part, most of what you'll be tested on the bar will involve this therapist issue. What's a confidential communication? Well, a communication is confidential if not intended to be disclosed to third persons. Oh, I'm sorry, let me go back to that slide. As you might imagine, we have a similar insider-outsider issue, one that we saw in the attorney-client privilege area, and I even have a very nice graph, or I should say chart for you. We have the patient. The rule mentions the therapist, of course. The rule mentions people who are present to further the interest of the patient in the consultation, examination, or interview. Now notice this person who's present to further the interest you might think of as a facilitator. You might think of as a patient representative, and it could be any of those people. It's just a more summary way of referring to, say, facilitators or patients reps, or maybe even therapist reps. We have these people called communicators, who are persons reasonably necessary for transmission of communication, which is very much like the attorney-client privilege. There's a reference to participants, persons who are participating in the diagnosis and treatment under the direction of the psychotherapist. Now, this may seem like therapist representatives, because, as you notice, they're under the direction of the therapist. But oftentimes, they don't have that kind of employee relationship that you often see in attorney-client relationships. It could be, say, another member of a group therapy. It could be a parent who's also participating in therapy with a child. It could be say, oh, what else could you have? You know, maybe like one of those Masters and Johnson therapy where they have a sex surrogate, which maybe I shouldn't say any more about. Let me just draw some lines for you. Sorry, this isn't quite as elaborate as what I did for attorney-client, but you get the idea. Lots of people potentially protected as long as anybody there is serving the interest of mental diagnosis or treatment. then you have a privileged situation. And this should help you with understanding White, because in White you have the Nadine talking to her therapist with a nurse standing there. Well, she's a nurse, you know, she's somebody who's there to facilitate treatment, so she's probably covered by the privilege. The interesting thing in White is that the nurse then goes and calls the cops, and you say, well, can she waive the privilege? But as you should know, based on attorney-client privilege, that a participant or a communicator or whoever this nurse is considered to be for purposes of our rules could not herself waive the privilege. So actually, by the time we get to the video that you won't see, you'll pretty much know what the answers are. Maybe that's best. Let's talk about exceptions. Exceptions to psychotherapist patient. Now, you should take a minute and recall the exceptions that we learned for attorney-client, right? What is it? Breach of duty, crime fraud exception. They're different. They're different. 504, privilege exception, proposed but not enacted, but true to the common law. Proceedings for hospitalization. I'm not even going to bother to read this. You just want to write this, right? Commitment proceedings. And what does that mean? Well, it happens all the time that a therapist is called and wants to testify that his client or patient needs to be committed. Okay? But it has to be that the therapist who is not protected is the person who decides that the person needs to be committed. Basically, this is the way they handle commitment proceedings, is that someone interviews the person who say comes in on a temporary hold, and that therapist then goes into court and testifies, and there's no privilege. The court needs to hear that information and relies on that information in making its commitment decision. The second exception is examination by order of a judge. If the judge orders an examination of the mental or emotional condition of the patient, communications made in the course thereof are not privileged under this rule with respect to the particular purpose for which the examination is ordered unless the judge orders otherwise. Now, you might think that's just like the last exception, but in commitment proceedings, the examination can be made on the patient's own request. There are provisions in state law for the police to make that kind of request. You know, they'll pick somebody up for vagrancy, and they'll take them to a hospital, mental hospital, because they seem to be suffering from emotional problems. That would not be a judge-ordered examination. But then on the other hand, you have someone who gets into the system through some other route. So say a criminal, or I should say a criminal defendant is accused of a crime, and then the judge says, I need to get a feel for this person's competency. This exception would allow the therapist to testify. And so write this: court-ordered examinations with respect to the purpose for which the examination is ordered. Now, that last language, with respect to the purpose for which the examination is ordered, is important, because there may be cases where you're examined for one purpose, and then the state wants to admit the results of that examination for a different purpose. And that would be a situation, okay, where, say, the judge says, I don't know if this defendant is competent to stand trial. And if you know anything about competency to stand trial, it has to do with your understanding of the charges against you and your ability to participate in the defense. Well, that interview that you have with the therapist may well lead to some very juicy information that the prosecutor would like to use after you are not found incompetent, you are found guilty, and then you're at a sentencing hearing. And the therapist, or rather the prosecutor, would love to say this is not privileged under the exception for court-ordered examinations, and the answer is no, it is privileged, because now you're using it for a different purpose. So that's actually an important little exception to the exception. The third exception we want to talk about is this: condition of an element of claim. No, I guess it is worded that way. Condition an element of claim or defense. Sorry. There is no privilege under this rule as to communications relevant to an issue of the mental or emotional condition of the patient in any proceeding in which he relies upon the condition as an element of his claim or defense. It sounds complicated. It's not. When the patient relies on his mental condition as an element of his claim or defense, he has essentially waived the privilege. Okay? And this is kind of a rare exception, or the patient is dead and another relies on the patient's mental condition. Okay? You can think of this as a form of waiver, that if you want to make your mental condition an important issue, then you've got to expect therapists to come in and tell the court what they think about you and what you've told them. As you know, Well, maybe you don't know, because many of you are a little young for this, but marriage is the best solace of human existence. Is it solace or solace? Well, it's something. It's something, that's for sure. This picture I took at I think it was my, gee, that's been a long time, when my daughter was in preschool. My son was in preschool, so it was about 6, 7 years ago, and this was just one of the many happy couples who I knew at that preschool. Lots of good memories. Anyway, we're going to talk about two types of spousal privileges. The first is testimonial, and I've mentioned this in the introduction to today's lecture. Testimonial means the testimony can be barred. So if you enjoy a testimonial privilege, you don't have to testify at all against your spouse. If it's a confidences or confidential privilege, then it only applies to certain types of communications, those communications being confidential. Let's talk about trammel. Trammel is the reason why I don't have you read the spousal privilege rule, right? I had you read the psychotherapist patient privilege rule, but not the proposed but not enacted rule with respect to spouses. And the reason I don't is because Trammell, and this is a good mnemonic, Trammell trammeled on the common law privilege. The defendant is Otis, charged with importing heroin. The witness is Elizabeth, same last name, his wife, who agreed to testify against Otis under a promise of leniency. And Otis, of course, hopes to claim the testimonial privilege and keep Elizabeth from testifying. And actually, that little clue is the answer to the next question. He's claiming the testimonial privilege. All right. What does the court hold? Very simply, testifying spouse holds the privilege. Otis can't keep Elizabeth off the stand. Elizabeth has the choice. Elizabeth can make a deal with the state since she holds the privilege. And think about what the situation would be like if Otis held the privilege, right? Could the state approach Elizabeth and try to get her to flip on him? Well, no, because she couldn't flip on him, even if she wanted to. Now, what can Trammell do? What can Trammell do? Well, unless one of the exceptions applies, and of course we're going to talk about those in a little bit, Trammell could still block confidential communications between him and Elizabeth. But it is a limited confidential communications privilege. Here's something you should always ask when you're considering the rationale for a privilege is why, right? Because remember, we know that the privilege is undermining truth, or at least we believe that, as long as we believe that people will still say something secretive, even if there weren't a privilege, that some information would be given to people in these professional and personal relationships. As long as we believe that, then we believe that that information is kept from the court and undermines truth. So we have to have a countervailing value, a substantive reason why the privilege exists. And that's why the court considers this is, well, why do we even have it? Since it's common law, they could decide not to have it at all. But they notice that the harmony and sanctity of the marriage relationship is very important. Now, here's where the reasoning gets a little bit fuzzy, to put it lightly. One might say, wait a minute, why doesn't giving the defendant privilege, the privilege foster harmony? Because notice what happens is the state, if Elizabeth holds the privilege, the state has a motive to put pressure on Elizabeth to flip on Otis. And when when Elizabeth testifies against Otis, that's not going to be good for the marriage. The government, or rather I should say Otis, makes this argument. And here's what the Supreme Court, I believe this was Rehnquist, responded. He actually uses this argument against Otis. He says the government is unlikely to offer a wife immunity and lenient treatment if it knows that her husband can prevent her from giving adverse testimony. And what does that mean? That means that we're going to increase the sanctity and harmony of the relationship by not preventing Elizabeth from flipping on her husband. It hardly seems conducive to the preservation of the marital relation to place a wife in jeopardy solely by virtue of her husband's control over her testimony. So if he could prevent her from taking the stand, she would say, damn you, Otis, I want to flip on you. And since she can flip on him, we predict that Otis and Elizabeth will be happily ever after. He'll be in jail, but, she'll come to visit him. All right, whatever you think about that, that's the rule. That's the rule. Okay, what are we looking at now? Well, you should immediately start to worry whenever you hear about something that could apply in the same place in different ways, right? That's fodder for exams. That's fodder for real-life considerations. One of the overlooked things in Trammell was the extent to which Mr. Otis, or I should say Mr. Trammell, was still able to claim the confidential communications privilege, which the court noted in a footnote. Right? That's an important point. Well, to what extent can he still claim it? To what extent is the testimonial privilege broader or narrower than confidential? Well, in some ways, testimonial actually seems broader. Okay? Testimonial actually looks broader. Does it include only confidential communications? No, for testimonial privilege, right? Because a testimonial privilege says you can't testify against your spouse at all. For confidential, of course, the answer is yes. That is why it is called a confidential privilege. Must the spouses be married when the communications are made? So would it be possible after a crime is committed, right, where there's knowledge between two people, they're just, just friends, could they then get married? And as long as it wasn't fraudulent, as you see, you can't deliberately get married to claim the testimonial privilege. But let's assume they just really fell in love after this crime that they both knew about. Could they still claim the testimonial privilege? In other words, do they have to be married when the communications were made, when the crime of interest occurred? And the answer is no, they don't. Confidential spousal privilege would require that, okay? Because it is the confidentiality of the communications, not the relationship, that we are questioning when we apply that privilege. So you might say now, wow, the testimonial privilege is bigger than the confidential privilege. Okay. But wait, must they be married when the privilege is asserted? Now, the answer to the testimonial spousal privilege is yes. Right? Once you're not married anymore, the testimonial privilege does not apply, but you do not have to be married when the privilege is asserted for the purposes of confidential spousal privileges. And the idea is the same as the reason that the privilege survives the death of a client in the attorney-client relationship, right? The idea is that you want, in the confidential privilege, to encourage communication, free communication between the spouses. But if I say something to my wife and I know as soon as we are divorced, I can no longer claim the privilege, then I may not be as free and easy with her. Now, don't get this confused with that whole joint client issue, right? The privilege is different. Spousal privilege, confidential spousal privilege, is not a joint client type situation. Does only the witness hold the privilege? The answer as of Trammell is clear for the testimonial spousal privilege. The answer is yes, right? That was the basic finding or holding of that decision. The answer is no for confidential spousal privilege. Both the witness and the person married to the witness can claim the privilege. So now the confidential privilege looks broader, and if you put it all together, you get this. Basically, you just got to learn these. You got to learn these rules. Now, they kind of make sense in terms of whether we're applying the testimonial to the spouse or the confidential privilege, but it's easiest just to memorize what they say and then worry about figuring out the rationales after you have some more thought or some more time. We're not done yet. Does the privilege apply in civil cases? The testimonial privilege does not. The confidential spousal privilege does. And for the rest of them, we're going to get the same answer for both, so you don't have to think too much about these other exceptions. What if one spouse commits a crime against another spouse? Do these privileges apply? Well, clearly the sanctity and harmony of the relationship is undermined, and justice would not be served by allowing one spouse to prevent the other spouse from testifying. Testimonial clearly doesn't apply. Confidential doesn't apply. What about spouse crime versus the child of the spouse? The answer again is no. We don't want to protect child abusers under the guise of the spousal privileges. What about joint participants in a crime? Okay, joint participants in the crime. Well, the answer here is also no. There is no spousal privilege if they jointly participate. Now, you might think, well, this totally dissipates because we're always talking about criminal behavior. In fact, you might even wonder about Trammell. It's like, well, weren't they joint participants? Not necessarily. When one spouse first reveals information to another spouse, before that other spouse has become an accessory in some way, and it could be an accessory after the fact where you assist someone in concealing a crime, that initial revelation is potentially protectable. And they do not become joint participants until the spouse who hears the information then enters into this agreement to keep the information secret, thereby making themselves an accomplice to some extent. Okay, so there's that initial revelation that is still important. All right? Now, of course, what can happen is that a joint participant can claim the Fifth Amendment right not to testify against themselves, in which case the state might then give them immunity, but then once they're given immunity, they might then claim that they are the ones that solely were responsible for the crime. So it creates actually a tricky situation for the state. Okay. One last question. Can one spouse refuse to testify under the testimonial spousal privilege if the other spouse wants to call her or him to present exculpatory testimony? So can you bar your spouse from asking you questions when on the basis that, you know, we're married, I don't have to testify against you? And the answer to that is no, you don't have that right to do so. Okay? All right. That's it for privileges. Oh, you know what? I don't have the People v. Nadine White slides up, but I will talk about that for a few minutes because I want to give you the issues that you should consider. And I'm sorry that we're now going low tech here, but you should probably have your additional reading packet. Can you see that? Your additional reading packet. And this will be helpful to you. The defendant is Nadine White. The charge is murder. And the decedent is Nadine's uncle. The prosecutor alleges that Nadine poisoned Martin with cyanide and then threw away a bottle of cyanide pills. Now, the prosecutor has some good reason to believe this. It turns out that her psychiatrist questioned her while she was under the influence of a truth serum. And she tells him under the influence of the truth serum that she is in fact the murderer and that she took the bottle of cyanide pills and she threw them into a lake. The therapist goes to Perry Mason with a tape of Nadine's confession, plays it to Mason, asking Mason for legal advice. Okay, immediately, you should realize that the issue here is what effect on the psychotherapist-patient privilege does the therapist's disclosure of the information to Mr. Mason do? What effect does that have on the information? Can Nadine still claim the psychotherapist-patient privilege with respect to the information? Can the doctor claim the attorney-client privilege with respect to the information? And to give you a clue, the answer to both is basically yes. All right. The nurse hears the statements that Nadine makes to Dr. Denaire. The nurse is also there when the statements are played to Perry Mason, Della Street, Perry Mason's secretary, and and I'm blanking on his name, but he's one of my favorite characters in Perry Mason. What was his? Paul Drake, his private detective. Really cool guy. Really nice plaid suits. Just love the guy. Real, blonde hair, very Southern Californian athletic look. But anyway, these people are all in the room. But one of the things you should think about when you go through this hypothetical is you should say, well, that looks like a facilitator. That looks like a communicator, right? And that's exactly right. Is these people, as part of either Perry's or Dr. Denaire's entourage, are protected by the attorney-client privilege and by the psychotherapist-patient privilege. Although I actually think that the attorney-client privilege is the one that most easily applies to those interactions when they're all together in a big room. Because remember that when the psychotherapist and Nadine go to Mason, they are both essentially clients of his, and the nurse is there to facilitate the communication among the four of them. Okay. Now, here's the interesting thing: is Mason then goes and looks for the pills, and what you should do in getting ready to think more about this hypothetical is you want to take another look at the attorney's responsibilities with respect to the disclosure of real information. Because, as you should know, or I should say real evidence, because as you should know, you can't privilege real evidence by giving it to an attorney. The real evidence has evidentiary value that is independent of the disclosure to the attorney. What can be protected is that source of the information, the fact that you are the person who gave it to the attorney. Because when you give something to the attorney, that is information that is communicated. It is intended to be confidential. You don't want others to know that you gave this piece of evidence to the lawyer. And the lawyer and his responsibilities to turn over real evidence to the police does not have to give up his client in order to do so. But the interesting question is, when Mason takes possession of the pills, when Mason removes the pills from their hiding place, thus making it impossible for the state to find them, when he gives them the pills, does he or does he not have the responsibility to tell them the location? And if he does, then notice the police get an advantage by Mason going after the pills. And I think probably there's a strong argument that he does. If Mason had left the pills alone, he really might be better off, because he could say, well, the state is never going to find these pills. And although attorneys have tried to argue when they've, say, extracted some piece of real evidence, from the potential grasp of the garbage man, say, they'll say, no, the state, has to prove that they inevitably would have found it, otherwise I have no responsibilities at all. The courts do not hold that. The courts say, look, if you make it impossible for the state to find the evidence, even if it's unlikely, you have a responsibility to turn that evidence over, and you have a responsibility to let them know where this information was, because if they found it, they would also know where it was found. And oftentimes, where it's found is in some ways connected to the defendant. The the information that remains privileged, even in a case where an attorney has to give the information to the police, has to tell them where the item was located. The information that's still confidential is the fact that the location came from the client. And there are ways that the courts will keep it from the jury. So, for example, the attorney would not be forced to testify. I'm the one that gave them the pills, because even the slow-witted juror would realize, wait a minute, that's the defendant's lawyer. The defendant must be the source of these pills, or of the information about where the pills were located. So look at White, read through it, because it does give you a great overview of the issues that you need to consider. Okay, that's it for today's material. I see I've gone through it. It looks like I've gone through it extremely quickly. And that's the nature of videotaped lecturing, I guess. It's a lot more efficient. So we don't have time for questions. But as you know, I'm out of town, but I will be available on email. And I'm definitely going to be very aggressive in getting back to your email questions the final week right before we get ready for exams. Okay? So I'll see you in the next lecture in just a few minutes for me, whenever you get the chance for you.